Funding for this program was provided by the National Institute of Justice.
Residential punishment, 19 years in Texas Department of Corrections.
Hello, I'm James Wilson. In the past, law enforcement agencies relied almost exclusively on criminal penalties to put bad guys out of business. But now they are fighting crime with a double-edged sword. New laws let police use both civil and criminal remedies to go after drug traffickers. This controversial weapon in the war on drugs is called asset seizure and forfeiture. Using either civil or criminal statutes, law enforcement agencies can seize property that they believe has been tied to drug trafficking. Civil statutes, however, require a lesser burden of proof. If a judge or jury finds that property should be forfeited, law enforcement agencies get to keep it. For example, when Florida police busted a notorious drug ring in Fort Lauderdale in 1989, they found that traffickers had been using a car dealership as the front for their illegal activities. The bust was a great success. Besides putting the drug dealers behind bars, it netted for police a whole showroom of Lamborghinis and Ferraris worth close to $2 million. The cars became the property of the Broward County Sheriff's Office. In its zeal to stop drugs, the Broward County Sheriff's Office began conducting what's known as reverse stings. Undercover police officers try to sell small amounts of crack cocaine in open-air drug markets.
Take it down.
When a buy is made, police move in and make an arrest. In addition to charging the buyer with the crime, police take possession of his car on the spot. Steve Berticelli, head of the Sheriff's Organized Crime Division, says the ability to seize property used by suspected criminals has helped his department to put drug traffickers out of business.
What we're doing, in effect, is dismantling the organization. We're taking it apart. And we're taking everything that surrounds that criminal conspiracy and removing that from the possession of its owner, who, in this case, would be a criminal narcotics trafficker.
The seizures in this case are not acting, in my estimation, as any type of deterrency. It doesn't stop any demand at all.
South Florida has been one of the headquarters of the modern drug trade. Drug traffickers found this international shipping port, bound by the ocean and laced with an intricate network of canals and waterways, an ideal place to do business. Some of the most innovative crime-fighting techniques also began here, and this area has led the nation in its adoption and use of seizure and forfeiture laws. But critics are wary of these powerful new weapons in the war on drugs.
My concern about the seizure laws is that they may not be properly used by the local police agencies. So much of this depends upon the good faith, goodwill, good judgment of the local police agencies, and not all of them are well managed, and so the potential for abuse is great.
I don't think anybody envisioned that the government would be looking to seize a 1990 Mercedes-Benz 450 SEL because it had 1 gram of cocaine in it. That wasn't the intended purpose when they passed that legislation. But that's the purpose. That's what it's being used for now.
People who lose their property rarely fight the forfeiture action because of the time and expense and the scrutiny of their personal lives.
You are presumed to be guilty before you ever get into a courtroom. The seizing agency keeps at your expense that item. You have to pay your own attorney's fees. If you win, you don't get your attorney's fees back. If you lose the item.
This entire warehouse in Fort Lauderdale is filled with forfeited goods. Florida police have become the owners of boats, planes, expensive cars, contents of entire homes and businesses.
Law enforcement around the country never anticipated the amount of money and the amount of seizures we'd be getting. We're talking in the multi-millions of dollars, and I think in the billions of dollars at the federal, state, and local level.
I got a $6,000 bid right deal.
Each year, the sheriff's office holds an auction to sell off the property they've seized. By law, proceeds from the sale of forfeited goods can be used by police for law enforcement activities.
None of the items that are seized and then later sold, none of the money that is ever gained is put back into treatment programs. I mean, all these motor vehicles that were seized as a result of the sheriff's reverse sting crack cases, none of it is put back into programs to assist the kind of people that he winds up arresting.
In effect, what we're doing is we're using the money we seize from drug traffickers to pursue them. And it's not using public tax dollars. We use it for investigation. We use it to buy or enhance the equipment capability of the agency itself, or maybe helicopters, computer systems.
The Broward County Sheriff has used its forfeiture funds to convert from a slow, manual examination of fingerprints to a high-tech, state-of-the-art fingerprinting system. But critics say that forfeiture laws may be giving police too much power, tempting them to pursue the wealthiest crooks, not the most dangerous.
This makes the police interested in seizing things that will benefit their own department. So they become entrepreneurs, and I think there's a kind of danger to that.
Critics of the forfeiture program are suggesting that law enforcement is becoming a bounty hunter, and what we're looking for is profit, and is a profit motivation. The overriding factor in a narcotics investigation is that you have to stop the drug trafficking. Our prime interest is shutting the narcotics trafficking down, stopping the illegal flow of money. If we can enhance that investigative capability by applying the forfeiture statute, that's what we're doing.
Many police agencies around the country are now modeling their forfeiture programs on the Broward County Sheriff's Office. Here in South Florida, police continue their aggressive use of the asset seizure and forfeiture laws.
The experience of South Florida is something to be learned around the country. And now other states have to adopt it. If they don't adopt it, they're not going to even be in the war against drugs. They'll just be playing that war of attrition, which is not a winnable war.
Here is how asset forfeiture works. Suppose you own a Rolls-Royce automobile. Lucky you. Suppose the government thinks that your Rolls has been involved with drug trafficking. There are two ways the government can take your car away from you. First, it can sue your car. At the trial, the burden of proof is on you to prove that the car was not involved. You don't have to prove the innocence of the car beyond a reasonable doubt, but you do have to show that most of the evidence supports your claim that the car was not involved in drug dealings. If you can't show this, you lose the Rolls-Royce. Second, the government can arrest you as a suspected drug trafficker and seize your Rolls-Royce. If you are acquitted, you get your car back, unless the government decides to bring a civil suit against the car in the way I described earlier. If you are convicted, the jury will decide whether you lose your car. When your Rolls-Royce, or home, or airplane, or cash is forfeited, it means the federal government is now its legal owner and can either use the property or sell it and use the cash. It will also share this money with state and local law enforcement agencies if they were involved in investigating the case. With me to discuss these matters are Ronald Goldstock, Director of the New York State Organized Crime Task Force, Chief Peter Ronstadt of the Tucson, Arizona Police Department, and Gerald Lefcourt, a defense attorney from New York City. Mr. Goldstock, how important is the asset seizure and forfeiture law to you in attacking drug dealing in New York State?
I think it's of critical importance. We've, in New York State, just begun to use it, and it's proving itself very, very effective, very worthwhile.
Do you think it deters drug traffickers? Do you think there's less drug trafficking today because of it?
I think the drug problem is just overwhelming, and I'm not sure that it's having a tremendous impact on drug problem itself, but it does a number of other things. It does interfere to some extent with the criminal activity, and we have an organized crime task force. We're concerned about the criminal organizations. It certainly takes away some of the profits that the organizations have and hurts the organizations themselves and stops them from going into other types of activities. There is some punishment. It denies criminals unjust enrichment, and it is revenue gathering. We get a lot of money from it, which supports our operations.
We hear stories of major drug dealers being extremely wealthy, and some of them may lose this property under an asset forfeiture proceeding. How big a fraction of their wealth do you really think you're getting away from them when you take their car, their boat, or their home?
Well, it depends on the individual. I mean, and it depends on the criminal organizations that are involved. If we're talking about the major Colombian organizations, for example, we're really not touching very much of what they have in Colombia, although some of the money laundering investigations have done that and have had some effect. On the other hand, suppliers in New York and around the country may be hurt considerably by having their assets seized.
You have heard the remark by a person on the film we just saw that this creates an incentive for law enforcement agencies to go after wealthy criminals rather than the most dangerous ones. Do you agree?
I think that's a problem. I certainly agree.
And how do you handle that problem?
Well, we sit down and think about it a lot in the office when we're determining how we ought to conduct our investigations, when we ought to use forfeiture, how we ought to resolve civil suits for money or other assets, and criminal prosecutions at the same time. And it's not easy.
Can the person whose property is lost appeal that decision to a higher court?
Yes.
And can the prosecutor appeal a decision that goes against them?
It depends. On the civil side they can, on the criminal side no.
Does the defendant very frequently win an appeal?
Well, it depends on the circumstances of the case.
Let me turn to Chief Peter Ronstadt from Arizona. Do you, as the executive of a big city police department, find that this asset forfeiture law really helps you in dealing with drug trafficking?
Yes, it does. We've only recently become able to make effective use of it. But I do think that it accomplishes a number of things, not the least of which is that we're sending a message out to the rest of the community that these assets, these ill-gotten assets, if you will, are at risk. And that they can be turned back into some constructive purpose. But primarily we use that type of tool for the same purpose, I think, that was just discussed previously. The idea is to put the bad guy out of business.
How big a deterrent is it if other drug dealers see their competitors, in some cases, lose a lot of assets? Is this going to make them think twice about being drug dealers, or is it going to allow them to expand their territory?
First of all, I don't think that it's particularly useful to look at only large drug dealers in terms of asset forfeiture and seizure. I think if you apply that across the board in the manner that was originally intended, in some cases, yes, it can be a deterrent. Other people will see that hey, this is serious business here, and there is a downside, there is a high risk, and these people may elect to choose some other kind of work. For people who are international drug traffickers, they're already aware that that's a risk. I'm not sure that we're deterring that, but that's really not the purpose. The purpose is not to deter. The purpose is to dismantle, if you will.
How can you be sure that when you're selecting cases for investigation, you're not going after people that simply have a lot of wealth rather than people who are especially dangerous or influential in the drug business?
I think when you sit down and decide how and why you're going to select a target, you look at it on the basis of who do we want to hammer here, not how much money they've got or how much can we recover. I think if it's remembered that the recovery is simply a byproduct, in the first place, we're not taking this person's money away from them. We're taking something that person's not entitled to have because it's against the law to gain assets through illegal means.
Let me turn to Gerald Lefcourt now for a moment, defense attorney from New York City. You have some real reservations with the way this law is used and perhaps with the law itself. What are those concerns?
Well, the first thing in the clip that you just showed, it was laughable to have that police chief say that taking somebody who was buying drugs for personal use is going after the drug trafficker. It's a joke.
This is the reverse sting.
Right, that's the reverse sting. They could have a prostitute walk up to a car in most of these states that have these laws and offer sexual favors. If the Mercedes-Benz driver agrees to take him, then you could take his car. Are you stamping out prostitution? It's a joke. This is laughable. Police officers and law enforcement are becoming bounty hunters. They're looking for the bucks. They like to have champagne parties when they seize a fancy car or boat. It's fun to them. They also then assign these cars for the men to use, and they drive around in them. What does all this mean to the drug problem? Not very much. The problem, though, and the danger is on other levels of the use of these asset forfeiture laws, because they're tearing down precious rights in this country. Defense attorneys such as myself are being subpoenaed to grand juries to find out who paid you your fee, and they're going to try to forfeit my fee, and that has been approved and it's now in law. They're also taking businesses, and before any trial determining any guilt or innocence of the people who own the businesses are often put under, and people lose their jobs, and homes are taken.
Let me just interrupt you here to clarify something for our viewers. All of these moves by the criminal justice system are, I suppose, in principle, subject to appeal to some review court. Have there been such appeals? Have the appeal courts ever found for the defendant in these matters?
Not very often, and there have been many such challenges. We as a nation are in a state of hysteria over the drug war. And this is the fifth war. I mean, every president declares war, and it gets worse and worse. And we are sacrificing more and more rights. And nowadays, somebody's home can be seized simply because a police officer can go to a clerk in a courthouse, not even a judge, and say that we believe that house was used for a drug deal, and they can come and take the house. The person who owns it and may have lived there with his family and children has no right to be heard throughout the country before that house is taken. They someday have the burden of proving that the house wasn't so used in order to get their house back.
Let me ask Chief Ronstadt about this concrete example. Do you go and take people's homes because drugs may have been dealt there, and then they have the burden of proving that they weren't?
It's conceivable that we might do that if, in fact, we knew or believed that we could prove that this place was being used and that basically it was involved. I think the example that was just cited, in my opinion, certainly is an extreme example. And I think the important thing to remember here is we're not talking about something that's outside of the court process or the due process. There is due process here. It is incumbent on the police to be able to at least back up with a preponderance of evidence what they believe.
Mr. Goldstock, why is it that the appeals courts have not listened to Mr. Lefcourt's arguments up to now? What is the principle here that they are using to decide that this is an appropriate means of investigating drug trafficking?
Well, I think it is an appropriate means, and what Jerry Lefcourt is suggesting is that on occasion it's being abused. And I suppose the easy answer is that all laws are subject to abuse. The robbery laws are subject to abuse. The burglary laws are subject to abuse. And because you find abuse in a number of situations doesn't mean that you get rid of the laws. The idea is to refine the laws and make them work better, but not to give up on them. In fact, forfeiture, I think, for all the reasons I suggested before, makes a great deal of sense. I'd also like to get back to another thing that Jerry suggested about the police having champagne parties. I mean, I think it is police, when they make a major seizure, feel very good about it. They've done good work, and they would like to celebrate, as anybody does in any field of endeavor where they do a good job. But by and large, I think they use the assets in a worthwhile way. And the issue of bounty hunting, I think, is more complex and sophisticated than we suggested. I mean, it may very well be that a police agency or a prosecutor's office thinks about seizing a lot of money, even though the person isn't the most dangerous, because they have that money then available to go after many dangerous people.
And that becomes the goal, to get the money. And indeed, now the whole system is being corrupted, because after the case starts, a criminal case, nowadays a defense lawyer like me, and I could never even thought of this 15 years ago, could say, you know, if we can offer the prosecutor some assets, maybe we can get out of this thing.
Have you done this?
Oh, sure.
So maybe you offer assets in exchange for
forfeiture. Oh, that's a popular new thing, day in and day out in places like New York. People are offering prosecutors money or assets.
Not as a personal bribe.
No, to forfeit, pursuant to a court order, in return for a lesser sentence.
Let me ask you this question. You have real reservations about this. Is there any way you believe an asset forfeiture law could be written and applied that would satisfy your concerns, or are you simply opposed to it generally?
No, I think proceeds of a crime in a civil context, where there is due process, and I don't object to civil forfeiture if there is fair proceedings, where somebody's home is not taken from them before they're heard. To me, that's not due process. And at least one court has said it's not either. If it's a fair civil proceeding, all right. I think it should be out of the criminal process, though. When you're prosecuting somebody for a crime, if he did something wrong, he's convicted, he should be punished. The judge or the prosecutor ought not be thinking about how much he can give you in order to get a lesser sentence. And the trial jury shouldn't be corrupted by the assets in determining whether that somebody is guilty or not.
Let me ask Chief Ronstadt first two questions. First, Chief, have you ever had a champagne party after having made a big drug seizure?
No, I've had a beer, though.
Yeah, now, do you, when you use the asset forfeiture law, tend to use it as part of a criminal proceeding, which is where Mr. Lefcourt's concerns come in, or do you tend to use it, or the authorities in your state use it, as a civil proceeding in which you hold a hearing to decide whether the asset should be forfeited or not?
We do both.
You do both?
We do both.
And how do you decide which to do in which case?
I hate to use the trite phrase, it's going to depend on the circumstances, but basically we do this after consultation with, for example, the Attorney General's office, if that's where the process is going to be, or our own county attorney, which is like a district attorney.
And how do they decide whether to use a civil or a criminal proceeding?
It's going to depend on the circumstances of the case, but in many situations it's simply not appropriate to seize property in advance. In the first place, what are we going to do with it? In many cases, what we do is we may ask the court to, in essence, put a business or a house or what have you, the ownership of that in some sort of receivership, and that's not the appropriate
Can I
word.
give you a circumstance that they
Okay,
use?
then I want to go, Mr. Goldstein. Go ahead.
A prosecutor determines they want a certain person to cooperate in the investigation. And so they go to that person and they say to him, look, unless you cooperate with us, we're not only going to prosecute you for this crime, which may carry, if it's a RICO or some such thing, 20, 40 years, but we're going to take every asset you have. We're going to leave you and your family penniless unless you cooperate with us and tell us what we want to hear.
Let me just
to me, that's a gangster talking.
You got 20 days for a hearing in my state, and at that point, that
well,
person's
not on the
got that
federal
right.
level. Not on the federal
Have
level.
you ever acted like a gangster in New York State, Mr. Goldstock? I mean, he is painting a very grim picture here. Do you use the possibility of asset forfeiture as a bargaining chip in a plea bargaining arrangement? Is that a standard procedure?
No, I mean, we have a strict office policy. If we bring a criminal case on the one hand and a civil case on the other against the same individual, it is split in the office and we don't negotiate the plea at the same time. Or if it is negotiated at the same time, it's done with different people in the office so that we ensure that we're not selling jail time for assets for ourselves.
But is there any revision of the asset forfeiture law as it is now written along the lines that Mr. Lefcourt suggested that you think would be acceptable and still leave in place the advantages you see in it? That is to say, limiting it to property that was the fruit of a crime and relying primarily on civil proceedings rather than criminal proceedings. Would this gut the law or would this help?
No, I would expand, not necessarily expand from what we have now, but expand Jerry's view on what can be taken. On the other hand, in terms of criminal and civil, I think that it is really two different things that we're thinking about. We make the decision because there are benefits going one way or the other way. If you're going to go criminal, you have to prove the case beyond a reasonable doubt. On the other hand, if you have to prove guilt beyond a reasonable doubt and you're going to do that in a trial, you might as well combine them in the same one and not have to go through the thing twice. It saves everybody time and money. On the other hand, if you're not going to prove guilt beyond a reasonable doubt and you're going civilly, you only have to show by preponderance or demonstrate probable cause that the goods were used in
Did you hear what he
activity.
said? He said, well, you can't prove it. It's an amazing concept what he just said. He said if you can't prove it beyond a reasonable doubt and you don't think you're going to be able to, why don't we do it civilly?
Well,
we don't have to prove a whole lot. All we have to do is throw it on the person whose house it is. Make them prove it. But put the burden on them.
That is law in our country. Basically, we resolve civil disputes by a preponderance of the evidence.
No difference in any other civil
law. Now, if you wanted to suggest that maybe
the burden is on the person whose property it is. In regular civil law, the person who brings the lawsuit has the burden of proof. It's only in this crazy mixed-up asset forfeiture law that the federal government...
If you wanted to change it to shifting the burden, if you wanted to change it from preponderance to clear and convincing, I wouldn't have any major argument with it.
But the burden ought to be on the government.
That may very well be the case. I wouldn't have a problem with that.
Well, that's not the way it is.
But that's right. But we can go through statute by statute in the books and find problems with each one of them. And I can show you how each statute has been abused. And you could probably do it better than I could. To pick forfeiture out and say this is unique, I think is wrong. It is a statute that should be fine-tuned, but the idea behind it, to deprive individuals of their ill-gotten gains, I think makes a great deal of sense.
I agree with that. If you're talking about getting proceeds of a crime and the burden is on the government and they could show that this is a proceed, a car or a house or a business, that's okay. But when you go in and take it and then make the person prove a negative, that they didn't, that's an outrageous system.
I would concede that. I don't have
Peter, do you have any problems with accepting Mr. Lefcourt's revisions of these laws? Or do you think that the changes he's proposed would, from your perspective in Arizona, really seriously impair the use of the asset forfeiture procedure?
Well, to some extent, I think that there are some of those safeguards, at least in procedurally, in our state, because we run into that sort of thing from time to time. But it appears to me that an attorney can't have it both ways. On the one hand, they say, gee, we should apply the doctrine here of whatever law, previous case law, and so forth. And it appears to me very clear that there's all sorts of precedent for this type of seizure and forfeiture, and for that to be decided on the basis of preponderance of evidence, just like any other civil process. I don't see any need to change it, and I think that it is an effective tool. And that if you start backing this off or start being selective, because it's hammering right now drug traffickers, you may as well hang it up. It didn't make sense to me. It appears to me that it's not broken now. Certainly, we have to be careful about abusing it. But why try to fix something that's not
What
broken?
about the argument that in the hands of perhaps an unscrupulous or overly ambitious district attorney, or perhaps in the hands of anyone, they could use the threat of asset forfeiture as a way of inducing a guilty plea? Do you see that happening in Arizona?
I see that in many cases we're dealing with people who aren't very nice people, and sometimes it's necessary to play hardball. To the extent to which a law enforcement person or a prosecutor or what have you does that, I think depends just as it would in any other type of criminal investigation or investigation. Certainly there is always a potential for abuse. There are safeguards to correct abuses or to prevent abuses. This I don't see as any different. The fact that it's drug trafficking doesn't make any difference.
What it prevents the courts in their normal review of plea bargains, convictions, and other matters from providing adequate supervision of this without a change in the law?
Because most courts don't want to get involved in this stuff. And what I'm talking about goes on out in the halls or in the offices of the prosecutors with defense lawyers trying to work out deals. Prosecutors are not going to come into court and say that we agreed to reduce the sentence from 3 years to 1 year because the defendant has agreed to give us $150,000. They're not going to say that. And they wouldn't even say it to you in their office. But does that enter their mind that they could show that they got this for their office and for future operations of their office? Of course it enters their mind.
Let me ask Chief Ronstadt one last question. What does your department use the money for that you obtain from asset forfeiture?
Use it for a variety of purposes, but first of all, it's subject to guidelines. It has to go through a budget review and so forth. There's outside review of this. But we use it to recover investigative costs, for example, to reimburse overtime that we've already previously expended. We also use it in some limited areas. We turn cash into capital property.
Gentlemen, thank you. A fascinating subject. Our time is up. Thank you, ladies and gentlemen, for Crime File. I'm James Wilson.
Crime File is a production of CF Productions Incorporated, which is solely responsible for its content. Funding for this program was provided by the National Institute of Justice, research arm of the U.S. Department of Justice.